Hi, everyone. Thank you for joining us today. Just our quick standard disclaimer. This presentation is for educational purposes only. It's not legal advice. It does not create an attorney-client relationship. We'll have some information at the end on contacting us if you have some specific questions. Dan's going to also be running some quick polls during this presentation. So if those pop up, please respond so we can get some good information from you. I'm just going to quickly go over today's agenda. We're going to talk about who is an independent contractor versus who is an employee. What are some tests for independent contractor status? The benefits of using independent contractors, some misclassification risks, and some information on finding help. And we normally do our weekly webinars in about a 15 to 20 minute time span. This topic is a little bit more involved, so we're going to do a little bit of a deeper dive. We're going to take a little bit more time. We're shooting for around 45 minutes today just to help you kind of plan things out. Another consideration is that if you're, depending on the size of your business, there could be some different options or the makeup of your workforce that we'll get into as well, just so that you can have that information. So what is an independent contractor? It sounds like a simple question. It sounds very straightforward. As you'll see today, it might not necessarily be that straightforward. So generally speaking, an independent contractor is a worker who offers their services to the public for a fee. So in other words, they're not a captive worker for one organization. They offer their services to the public, not just one place. They're not economically dependent on a single company, so they're not attached, as we were just discussing, to one particular organization. They may work for many different organizations, and simply spoken, an independent contractor is not an employee. So some additional factors with what is an independent contractor. So typically that individual would charge a service for their fees. They would engage them only for a specific period of time, not ongoing. They retain control over their method and manner of their work. They retain economic independence, and they're free to offer their services to more than one company. They're responsible for paying their own taxes, and they're not covered by most employment laws. So let's talk about this a little bit. Really, if you're using an independent contractor, you generally have the right, if the person is truly an independent contractor, to set the outcome of the project. You can't tell them how to do it, but you can set what you want to have. If you're using independent contractors, as you know, you issue them an IRS Form 1099 for their income reporting purposes. You don't have an obligation to provide benefits to those individuals. And as we had touched on before, in looking at an independent contractor determination, they're generally free to offer their services to the public and work for other clients. They should have their own business, basically, and offer services on their own terms. So, importantly, in considering what is an independent contractor, what do they not do? Independent contractors typically don't receive company-sponsored benefits, such as vacation, health insurance, retirement benefits. They typically don't perform the same work as the company's employees. For example, a graphic designer might be an independent contractor when they offer graphic design services to some other type of business, say like maybe a shoe manufacturing company. However, if that graphic designer is hired by a design service company, then they would likely need to be classified as an employee. Independent contractors and employees are generally not interchangeable. You also need to look at whether an independent contractor has the indicia of an employee based on the specific circumstances. We'll talk a little bit about this more in a moment. But for example, in some situations, an independent contractor needs to access the employer's workplace. Think about that. People coming in, they need a badge. So in order to avoid that indicia of having that person be an employee, a lot of companies, if they are using on-site independent contractors, they would issue the contractors a different type of ID badge. It would maybe look differently in terms of color, in terms of size, in terms of accessibility. It would not be an all access badge, and maybe there would be an expiration date on it. So that would be something where you're wanting to avoid those indicia of an employee. So independent contractor versus employee. Now, again, this might sound like a basic type of foundational question, like what is an independent contractor? Well, what is an employee? So compared to an independent contractor, an employee is subject to very significant oversight and control by the company they're working for, their employer. So they are, in contrast to an independent contractor, paid by wages. They receive benefits. An employee is generally employed for a continuous period of time, and they do whatever they are told to do by the employer. They pay their taxes through withholding via the employer. In other words, the employer is taking the required taxes out of their pay for them. They're not paying directly into the government like an independent contractor would do. Generally, an employee is economically dependent on the employer. They get all their work from the employer. They're not working and hiring themselves out to different people. And they're also protected by applicable federal, state, and local employment laws. So employees have laws that they are subject to, unlike an independent contractor. This is a big area where we receive quite a lot of questions, and that is kind of how do I classify this person that's performing work for me? Just as an overview to start that discussion, do not rely on generalizations or labels to determine if someone is an employee or an independent contractor. Simply referring to a worker as an independent contractor, even if they agree to be classified as an independent contractor, and even if you sign a document with them saying, oh yes, we both agree that my work is being performed as an independent contractor, that's not enough. It's not enough also if you've got a tradition within your industry or within your specific business of saying the people that do ABC work are employees and the people that do XYZ work are independent contractors. That's not enough under the law. You've got to take, as an employer, a more in-depth look at each person and what they're doing. And what you really want to look at is, the facts of what an individual is doing. Not a label, not a signed document. You want to look at the facts of the work the person is performing to say whether they are an employee or an independent contractor. You'd also want to apply the appropriate independent contractor tests. Now we're going to get into and discuss the tests, and just as kind of a preview, there are a lot of them. They are in depth, and more than one test could apply in more than one situation. So what you'll see is that this is a complex area of the law, and it's a complex area of operation for employers. And then once you are looking at the test or tests to determine if someone is an employee or independent contractor, another consideration that you would want to consult with us on if you are one of our clients is, how are those tests applied in the jurisdiction where you're operating? How would, say, the State Department of Labor and a wage and hour claim apply that state test for independent contractor or employee, or if it's federal, how would a federal test be applied, and would those state and federal tests work together? That's where you can see very quickly that in addition to the number of different tests, the application of those tests also gets into kind of an area where a lot of employers should seek assistance to stay on the safe side of things. We're going to talk about the tests, and there is a number of them. We're going to go through them, and the reason we're going to do that is because all of the factors are important. Each factor in the test is relevant to your determination of whether a worker is going to be an independent contractor or an employee. And as I had just mentioned a moment ago, there's not a single test that works in every case, in every geographic jurisdiction all the time. Sometimes, depending on the facts of the situation, more than one test may have to be applied, and that could be, again, federal, state, or both laws. So some of the tests include the control test, the common law test, there's the economic realities test, and state and local tests. Your compliance is often complicated, as I said, because of all the different overlays that could happen. And in fact, a lot of times with state cases, a worker could be found to be an independent contractor for some purposes and an employee for others. It can be confusing. You could also have an employee within your organization who provides two different services to you, and they may be found after applying a test or test to be an employee for some of the work they do for you, and they may be an independent contractor for other work they do for you. So that compliance challenge would need to be looked at. And then to complicate it all even more, there could be within a state, for example, a court that has interpreted a test differently than federal law might have applied it. So as I said before, this can really get into an area of complexity that employers are best advised to seek out some help if there are questions. We're going to start off with one of the big tests at the federal level. That's the control test. This is the test used by the IRS, used to determine whether the worker is an employee, and this is for federal tax purposes. Recall, as I had just mentioned, you're going to have different tests that apply for different reasons to the same worker. So the IRS control test comes into play if there's a question on a tax, a federal tax issue with a worker. So with that, the IRS looks at three aspects of the worker's control or independence. The first is behavioral control. When the IRS looks at that, they would say a worker is an employee when the company has the right to direct and control them. This behavioral control factor considers whether the company controls or has the right to control not only what the worker does, but how they do it. Sometimes with an independent contractor, you are not able to tell them how they do something. They just have to get to the result. The other thing that the IRS would look at under the control test would be financial control. That refers to whether or not the employer or / company has the right to control the economic aspects of the employer's job. So that means factors that the IRS would look at would be how they're paid. Are they paid per project? Are they paid per day? Are their expenses reimbursed? That's another thing the IRS would look at. And who, whether it be the worker or the person bringing the worker in to perform the work, who is providing the tools and supplies for the job. The IRS would also look at the type of the relationship between the parties. They would dig into, how does the worker see the relationship? Do they feel they're an employee? Are they an independent contractor? How does the employer or company who's bringing the person in to perform work, how do they feel about it? They would look at that as well. If there's a written agreement, for example, that can go to the type of relationship that the IRS might say, okay, this could lean towards independent contractor. However, if even with an agreement in place, if the company is providing some sort of benefits beyond just pay, to the worker, the IRS would say, well, that leans to employment, not independent contractor. If the relationship is for an indefinite period of time, it's not for one project, or it's not for a 3-month fill-in, for example, they might say, okay, that's an employee. Or if the services that are provided are key to the regular operation of the business, the IRS under the control test would say, well, that is leaning towards being an employee, not an independent contractor. And again, as we go through these tests, keep in mind that they apply to different situations. So this was for, as noted, federal tax determination purposes. Another big test that gets used by courts when there is a question of whether a worker is an independent contractor or an employee is what's known as the common law Darden test. So Darden was the name of a case, that's why it's in italics. It's a US Supreme Court decision, so it still has precedence to this day from 1992, even though it's over 30 years old. The case is still good law and is used by federal courts for questions regarding independent contractor or employee relationship. It's named after an insurance agent named Darden, who sued his employer to recover retirement benefits under ERISA. So with this Darden test, again, at the federal level, it's used to determine whether a person is an independent contractor or an employee for actions that involve Title VII of the Civil Rights Act. So that could be like a discrimination case. The Americans with Disabilities Act, ADA, so some sort of disability issue that would be brought in federal court, the Darden test would be used. Similar for the Age Discrimination in Employment Act, the Affordable Care Act, and then the Employee Retirement Income Security Act, ERISA, as we just noted. With the Darden test, there is a look at a number of factors, each of which is important, and each of which needs to be considered by an employer if this issue comes up. So those include the skill required to perform the job, who's supplying the supplies and tools, as we noted even with the previous test relating to the IRS under control, where the work is performed, what is the duration of the relationship between the parties? Is it, indefinite, or is it for a specific period of time or project? The company's right to assign additional projects to the worker. That's a factor that comes in with the Darden test. The extent of the worker's discretion over when and how long to work. So that can go into looking at sort of a control factor. The method of payment is also what's looked at under this test. And again, this relates to federal law, basically federal employment law cases. The worker's role, if any, in hiring and paying assistance. The regular business of the company and whether the work performed is part of that business. And we talked about before the shoe company hiring the graphic designer. Well, a graphic designer is not a normal part of shoe manufacturing. That's just another example of that. And the company status is in business, meaning they are working as an ongoing concern. A way to sort of distill the Darden factors down to kind of 5 basic points is control and supervision of the worker, occupation, nature of the skill required, who's responsible for costs, how is the person paid, and what is the length of the commitment. There is sometimes, and I don't have this on the slide, but there is sometimes something used what's called the hybrid test, and it uses the Darden test with another test we're going to discuss in a few moments called the economic realities test. But that is just another example of how there can be, with these set out tests, once they're interpreted by the court, there can be different applications of them in practice if you're going through some of these questions. Another big test that's out there that a lot of people have heard of is called the 20-factor common law test. That was previously used by the IRS prior to them adopting the more recent control test, but the 20-factor test was used by the IRS, and it's still used by a number of states when there are questions that come up with a worker involving whether they're an employee or an independent contractor. And we're going to talk about the factors here. So instructions. An independent contractor generally should not be given instructions or procedures regarding details or methods and should not be supervised. Again, 20-factor common law test. Training is a factor. An independent contractor generally should not need training and ideally should have had previous expertise in performing the work. Contrast that with an employee where they are often heavily trained. Integration with the company's operations. And independent contractor services are usually separate from the client's business and are not integrated or merged into it. You'll see that kind of factor as an ongoing theme with some of these items we're discussing today. The services are rendered personally. An independent contractor usually has the right to employ others and assign them to perform the services in their place. And that could go back again to, can they hire someone to help them without getting input from who they're performing the work for? Hiring, supervising, and paying helpers. If the company is going to supervise or direct the work of an independent contractor's assistants, that would support a finding of employment versus independent contractor relationship. A true independent contractor would select, hire, and reimburse their own assistants. Continuing relationship. An independent contractor tends to be hired for a finite project and the relationship ends when that project is completed. An indefinite or continuing relationship is indicative of an employment relationship. Set hours of work, requiring a worker to work a specific time frame. You got to work from 8 to noon and then from 1 to 5 every day. That would be a clear indication of control and would indicate an employment relationship under the 20-factor common law test. Full-time or exclusive work. With an independent contractor, you're generally free to perform work for many companies at the same time. You put in a few hours here, few hours there. You're doing more than one thing versus being required to work full-time or exclusively for one organization. That would lean more towards that the worker is an employee. Continuing on, what is the location where the services are performed? So requiring work to be done on company premises implies a degree of control over the work, which suggests an employment relationship, not an independent contractor relationship. Independent contractors ordinarily work wherever they choose, although some types of work may dictate that they have to work at a specific site, but in many cases they are free to work from wherever. Specifying the order or sequence of work. An organization or an employer generally has control over the worker if it specifies by contract or in practice the order or sequence of work. That would lean more towards employment versus just saying, here's the project, we need the finished product. That would lean more towards an independent contractor. Oral or written reports. If a contractor is required to provide some sort of progress reports on a regular basis, that would lean more towards an employment relationship versus an independent contractor relationship. And just as a kind of overview, with this 20-factor test, what generally occurs is that all the factors are analyzed by the organization, and then they just make a determination based on what the outcome is, how it weighs more heavily in factor of employee or independent contractor. Payments. An employee is more typically paid at regular intervals. So what is that? Weekly, bi-weekly, bi-monthly. While an independent contractor is more likely to be paid a negotiated flat fee, or they submit a bid and then they're paid for the full job. Paying the worker through payroll would suggest an employment relationship, which is pretty obvious. But paying through accounts payable on receipt of an invoice leans more towards an independent contractor relationship. Business or travel expenses. Few expenses are reimbursable to an independent contractor, and those that are should be extraordinary. All normal office expenses should be paid for by the independent contractor. Tools and materials, an independent contractor generally furnishes their own. Investment, independent contractors are expected to invest in their own business, meaning they have more skin in the game financially. Profit and loss, employees are generally shielded from profit and loss, whereas independent contractors risk their investment that we just discussed in order to get a return on what they're doing. Number of companies with whom an independent contractor works. As we had discussed previously, an independent contractor, a true independent contractor, can choose with who they work for and work with many people at once. If somebody is working exclusively for one person, that leans more towards an employee relationship. Advertising services to the general public, business cards, letterhead advertising, that could show you're an independent contractor. The right to fire someone. With an independent contractor, their agreement with an employer allows for contract termination versus termination of an employment relationship. And then finally, the right to quit. An independent contractor is contractually bound to complete the assignment and liable for any failure to deliver a specific result. That leans more towards independent contractor and breach of contract. The economic realities test. This is a new rule that became effective last month, March 11 of 2024. This relates to the Fair Labor Standards Act. So we're still kind of discussing in the area of federal law. And as we had talked about, each of these tests can apply under different federal laws depending on what the issue at hand happens to be. So the economic realities test really comes into play with, like, say, a wage and hour issue under the Fair Labor Standards Act. So to determine whether or not someone is an independent contractor or an employee under the economic realities test, 6 factors are going to be reviewed. The opportunity for profit or loss depending on managerial skill. Investments by the worker and the potential employer, those would be compared and contrasted. The degree of permanence of the work relationship, again, as we've discussed with some of the other tests, is it one project or is it ongoing? The nature and degree of control, the extent to which the work performed is an integral part of the potential employer's business, and then the skill and initiative of the worker involved. So that's a newer test that came up. Now we're going to shift over to state tests, and we're going to talk about one big one that people have heard about, particularly if you employ workers in the state of California. You're probably familiar with the ABC test, and even though there are a number of legislative carve-outs for the ABC test, generally it applies broadly in California and other states as well. This is a pretty narrow test, and it is a high bar to clear to show that someone is truly an independent contractor. So the ABC test means A, absence of control. The worker has been and will continue to be free from control or direction over the performance of their work. The B factor is business of the worker. The worker is either outside of the normal course of business for the client, company, or performed work outside of that company's places of business. And then C, customarily engaged. The worker is customarily engaged in an independently established trade, occupation, profession, or business. So going back to our example from before, the graphic designer hiring out to the shoe manufacturer, that would be an example of the C factor, where the person is working on their own, they have their own business. The B factor would be their graphic design is outside the normal work of a shoe company. And then A, generally speaking, a shoe person or shoe company wouldn't tell a graphic designer necessarily how to do their design job. Another example I've used before is you've hired a carpenter to remodel your break room. You're a software company. The carpenter would easily, most likely, satisfy all 3 requirements of the ABC test because they are not controlled in their work by the software people. They do work that's outside of software, and they are customarily engaged as a carpenter. So that's an example of the ABC test. So what are the benefits of using independent contractors? Well, there's a ton of them. That's why it is so difficult to overcome some of these tests, because if these tests did not exist, a lot of companies may just say everybody's an independent contractor, because they would get out from underneath a lot of compliance obligations that they would otherwise have with an employee. So if you're working with someone who is a true independent contractor, you're free from your tax and insurance obligations, your employment law compliance, as I just mentioned. You don't have to provide benefits. Immigration law compliance is not the same for an independent contractor. ACA compliance. So breaking those down a little bit further, tax and insurance obligations, you're avoiding the items that are kind of shown here on the screen, everything from the federal, state, and local taxes, Social Security, and Medicare, unemployment, and workers' compensation. With an independent contractor, you are not subject to the same employment law compliance as you would be with an employee for the, alphabet soup of laws listed here. Some of the big ones, again, Fair Labor Standards Act, Title VII of the Civil Rights Act, Age Discrimination and Employment Act, the Americans with Disabilities Act, etc. Independent contractor, not subject to that. Employee benefits, you don't have to provide an independent contractor with employee benefits, as you can kind of see here on the screen. Health insurance, vacation, sick days, things along those lines. And finally, with an independent contractor, you don't have the immigration law and ACA compliance obligations for an independent contractor that you have as a company with an employee. So all of those reasons we just listed make it very attractive, because they lighten the burden of compliance, they lighten the risk of claims, they do a lot of things where if somebody's an independent contractor, not an employee, as an employer, you're less burdened by working with them. But now we've got to start talking about all of the implications of those tests that we've been discussing, and what happens if there is a misclassification by an organization of one of their workers. Misclassification means the organization has said, oh yeah, that person is an independent contractor, but then either a state investigative agency, federal agency, someone else comes in to take a look at the actual relationship. If a court or an agency determines that the person has been misclassified, then you're looking at some potential consequences that would not be very fun for an organization. The consequences can be very serious. They can be very expensive. They include back wages and overtime pay if a court or government body finds that the person has been misclassified. Some of the consequences can involve, again, back wages and overtime pay. Employee benefits, that's not going to be cheap. Disability payments, workers' compensation. There can be tax and insurance obligations that would have to be backfilled. Liquidated damages may be payable, and also civil monetary penalties from a court or government agency. So the stakes are actually quite high if you're looking at the risks of, hey, we're not sure here, we're just going to go ahead and say independent contractor. Well, if that comes back down the road to bite you, these are some of the areas that could have very serious, financial, administrative obligations for an employer. There's also, in addition to some of the penalties we just listed, there's also some compliance issues that could come into play. Not just money, but what if somebody who later is determined to be an employee needed a reasonable accommodation, it was not provided? That's an ADA disability discrimination claim. Or if somebody had worked as an independent contractor, but they later should have been determined to be an employee, should have been given FMLA, that comes into play. There's a plant closure. All these discrimination laws is listed on the screen. These are other areas in addition to the previous slide where a misclassification issue could come back to bite an employer if somebody is not properly determined to be either an employee or an independent contractor at the start of the relationship. Another area of concern is the Affordable Care Act. You do not want ACA penalties of any sort at any time. So that's just, this slide just quickly shows another issue that can come into play. Tax and insurance obligations, we sort of touched on that, but there can be, if this went on for a long time, someone was misclassified as an independent contractor, should have been an employee, there can be years of unpaid federal, state, and local withholdings. The Social Security and Medicare contributions, work comp, as we talked about, and unemployment insurance premiums, and then plus all the interest and penalties that a government body or court can impose. It's very, very steep. So who are some of the targets of enforcement and litigation by these government regulatory agencies for misclassification cases? Who is being looked at in an industry or as a business to see if they have workers improperly classified as independent contractors when they should, in fact, under the various tests, be called employees? Well, construction, landscaping, nurseries, that's a big one. Transportation, trucking, delivery drivers, janitorial services, security guard services, nursing, home health care, childcare, restaurants, catering, salons, wellness businesses, spas, staffing, all types of staffing from general through skilled, and hotels and motels. We work with and advise clients in all of these industries, and we are very well versed on the risks in working in these areas if you have any workforce that may be an independent contractor. Okay, let's talk about a case study. We have our friend trainer Jane. So Jane is a certified personal trainer with several years of experience. She teaches in individual and group sessions at 3 different gyms, including Bolt. That's the name of our company here. Bolt is part of a large chain of gyms, and consistent client experience is part of its business model. For that reason, Bolt asked Jane to wear a Bolt name tag and Bolt activewear when she's teaching. Bolt schedules the sessions, handles registration, collects session fees from the Bolt gym members, and pays Jane a flat fee for each session. Jane must commit to at least 10 session hours per week, and at least 4 hours for every Saturday for consultations. Jane enjoys the flexibility and variety of working at different facilities, but she prefers the arrangement with Bolt because, unlike other gyms, she is not responsible for administrative tasks such as scheduling or collecting money. Also, Bolt has the best equipment of the company she works for and does not charge her rent for her studio space. Recently, however, Bolt canceled several of Jane's sessions at the last minute because of low registration numbers. Jane was able to replace some of the lost income by scheduling extra sessions with a non-Bolt gym, but she was not paid for the time she spent at Bolt setting up and putting away equipment in preparation for the sessions that Bolt ultimately canceled. When she complained to a fellow trainer, he said Bolt should pay her for that setup time, even though the sessions were canceled, because the fellow trainer said, hey, you're an employee. So the question here is, and give you a minute to think about it, or a second to think about it, is Jane's fellow trainer correct in that she is an employee of Bolt? And now that you've thought about it, the answer is she probably is an employee. Many of the facts in this hypothetical suggest an employment relationship exists. For example, Bolt exercises a significant degree of control over Jane's work, including scheduling sessions and consultations. Bolt registers the participants and collects payment. Bolt requires a minimum number of hours from Jane, which must coincide with Bolt's session schedule, and requires Jane to wear its branded clothing and name tag. Jane personally performs the work for Bolt and does so at Bolt's location. Additionally, Jane is paid a flat fee for each session. regardless of the number of participants, and is paid nothing if Bolt decides to cancel the session where she's scheduled to teach. Her investment is minimal compared to Bolt. Bolt provides all the studio space and equipment and covers advertising and overhead. Jane is not paying that. And finally, Jane's work as a personal trainer may be considered integral to Bolt's physical fitness business. I would say that is a very important factor to consider in this type of situation. So what do? As noted at the very beginning of our discussion, this is a complex topic. There are federal factors to consider. There are state factors to consider. More than one test at the federal level could apply to an employee. A hybrid of federal and state tests could apply to an employee. So what should a company do when they're faced with a question of classifying a worker as either an independent contractor or an employee? Well, some of the best practices that are out there would be to use an independent contractor agreement to establish the terms of the working relationship. So if you are working with an independent contractor, it's best to have an agreement. It's also a best practice to avoid using former employees as so-called independent contractors or having, quote again, independent contractors, quote unquote, do the same work as an employee. Avoid using independent contractors to perform work that is integral to the business. Do not reimburse independent contractors for business expenses. Pay contractors by the project or by an agreed on flat fee at regular intervals, not by the hour, week, or month like you would an employee. And don't provide independent contractors with employee type benefits like paid time off, holidays, sick leave, retirement benefits. Now, as we have talked about, this is a complex issue. It's a vexing issue for a lot of employers trying to make a determination. So how can we help you? Well, we are up to speed on the laws. We keep track of the new changes such as the economic realities test that we talked about that came into effect last month. We're aware of these changes and how that they can affect employers in their decisions with classification. We also, as we just talked about as a best practice, we have independent contractor agreements. We have a good document or documents that we use. If that relationship is being put in place, we can also look at documents for people you may be considering using as an independent contractor. We can perform or help you perform a worker status analysis. We look at the facts of the situation and apply the legal rules to whatever situation you may have. And additionally, we provide legal advice to you. What that means is it's not a disclaimed HR service that provides you some information and says, oh yeah, by the way, go talk to your lawyer. We are your attorney. We provide legal advice to you. That legal advice is backed by our insurance coverage, all those sorts of things. We have rules we need to operate under. So it is a final answer for you on a question with actual legal advice. This is a very important area to not make a mistake in. Federal and state agencies are always looking for misclassification claims. And again, I know this is a lot of information to take in, and it's kind of an eye-opener when you look at the potential costs of making a wrong decision. So because a lot of our clients feel overwhelmed by trying to make a decision on their own, they know they can come to us for that legal advice because they have unlimited access to our employment attorneys with myHRcounsel through their subscription. And if you want to learn more about our services, if you're not currently a client, you can contact us at info@myHRcounsel.com. Thank you for joining us. You deserve peace of mind, and we provide you with answers that you can rely on. I hope everybody has a great rest of their day, and we'll talk to you next time around.
Thank you, Michael. That was some really great information that gave attendees today a lot to consider. If you would like us to help classify your workers and are already a client of ours, you know that you can go on to our Ask an Attorney client portal, open a ticket, and speak to an attorney exactly like Michael. If you're a business owner or an HR professional and aren't yet a client of myHRcounsel, but understand the value of having unlimited HR and employment legal advice whenever you need for just $149 per month, reach out to us at info@myHRcounsel.com. Have a great day. We appreciate you, and we hope to see you on the webinar again soon.